Welcome to yet another Glasgow Loves EU lockdown chat, and we're very delighted to have with us Alisdair Matheson tonight. He's a practicing civil litigation and professional negligence and construction law lawyer. Is that right? I've got that all written down to try and get that right. Alisdair was a founding member of our group, and although his practice doesn't focus on EU law, he did study it at university, so he has a more than a passing interest, especially as he's been very involved in pro-EU groups like ours. In common with many other lawyers, it's played an integral role in his day-to-day work for many years. His other passions include rugby, although now he's generally limited to coaching his 3 young children. And we may get one of them come in. I love it when that happens, but maybe not tonight. It does sometimes. Anyway, I think, and I hope everybody agrees with me, this is the perfect day to be talking about EU law. And we will get on to today's breaking news later on the UK Internal Market Bill. But we'll scamper through a bit of EU law background first. So the first question we have is, can you give us a quick explanation on the difference between treaties, regulations and directives? Okay. But not too long.
No, right. I'll try and be quick. So start doing that if I'm taking too long. I think first of all, it's important to remember where the European Union came from. So you were mentioning I studied European Union law at university. I actually studied European Communities law at university. It's that long ago. Yes, I know I look youthful, but it's that long ago. So you're going back to a I think it's important to set the stage. Going back to a period where, if you imagine today and go back to 1990, in that period, you'd had 2 of the greatest conflagrations that the continent had ever seen. And there were a lot of people very eager to avoid that happening again. And as a result of that, there were discussions that didn't ever go as far as Churchill's suggestion of a United States of Europe, but measures to try and bind the economies and societies of principally France and Germany together, so that war would become very difficult, so that it becomes so entwined, as we will probably find out if we end up leaving without a deal, that if economies are very closely entwined, it's very difficult to then sever the relationships. The first area that they thought about bringing together was the coal and steel industries, and that became the first of the European communities, because mid-20th century warfare relied on coal and steel to move forward. So that was 1951, the European Coal and Steel Community. Then, keeping it separate was Euratom, which was for the management and trade in nuclear technologies and materials, etc. And then the third of the communities was the EEC, the European Economic Community, which is often called the Common Market back in the day, but never formally. That's just an appellation for it. So you had 3 communities for much of the life of the communities, now the European Union. And we were saying just before we went on, I mean, that goes back nearly 70 years, which is a third of the age of the United Kingdom. So they have been around for quite a while. Now, the treaties are, in effect, the constitution of what has become the European Union. There have been a number of reform treaties and accession treaties that have amended things over the years. And now we've got to the stage where it's now the European Union, and Euratom sits slightly separate to that. But realistically, what we're talking about now is the European Union. Now, the treaties are, in effect, as I said, the constitution, although very deliberately the term constitution is not used, because that was used in the previous iteration of the treaty that failed on various national referenda to get it across the line. So the treaties set up and constrain the European Union. Its competencies have moved, but they have moved with the consent of all the then members of the European Union, and ultimately every member state signed in the dotted line and knew what they were getting into. In particular, by the time the latter treaties were signed, they knew that European Union law included the doctrine of supremacy, of direct effect, and was a pervasive influence in our own domestic system. You've therefore got the treaties. So they're the foundation. Then the next in the tiers of legislation are regulations. Now, they are measures which are of general application, applied across the European Union, and are directly effective. So if you have an EU regulation, it is the same as an act of parliament. A good example of that is the GDPR, the General Data Protection Regulation. So that supplanted the Data Protection Act, which we had in the UK, which in itself was implementing a directive. We'll get onto that. But that regulation is the same text, whether you're in Croatia or currently in the UK, because it still applies, despite us being in the transition period. And therefore it has, or is aimed to have, common application. You then have, next down in the tier, directives. Now that is a compulsory piece of legislation, and it is legislation, although it is aimed at getting member states to legislate themselves to implement the policy that it's bringing into effect. It might have been impossible to agree on a final text, for example, or there might be differences in approach, say between Germany or Spain or Portugal, in how they're approaching that particular area. And all it will generally have is a selection of aims and then a date that has to be implemented in domestic law. Now, that kind of legislation, directives, often led to a great many statutory instruments in the UK rather than acts of parliament. Although I said the Data Protection Act, that was unusual in that it was implementing a directive which was supplemented by a regulation. Most directives are implemented by statutory instruments. For example, what was very much a cause célèbre when I was at university was the transfer of undertakings protection of employment regulations, and whether they went as far as they needed to implement the then directive that was saying our aim is to protect employees' continuity of employment when the business is sold. So you get directives. Now, below that, or separate to that, you've also got decisions. Now, decisions are specific things that apply to a particular set of circumstances or a particular organization or even an individual. So an example of that might be that the Commission has approved a particular measure of state aid, subsidy to save a blast furnace in Wales, or a car part supplier in Germany, or something like that. They might issue a decision saying, we've looked at the facts and this falls within the correct permissions given in a regulation, etc. So you have a hierarchy of different bits of legislation. Now, if you're talking about how they are drafted and how they come into being, treaties have to be signed off by the member states, and they have to be ratified by the way that each member state holds the international treaties required to be ratified. So in the UK, we don't actually need to do anything because our constitutional law is constitutional law by accident. So it's not the same as Belgium. We heard, obviously, with the Canada deal last year, I think it was. It seems like a distant history, where because certain elements of that trade agreement affected the competencies of regional governments in Belgium, which is a federal state, their permission to effectively sign away some of their rights or deal with their rights was required. So there's a wide variety, but ultimately all member states have to agree for changes to the treaties. Regulations and directives are different. It is a horrendously complex process in the treaties called joint decision making, and I'm not going to go into detail, but basically it was a fudge to try and maintain consensus and get to something that might not be what the policymakers really, really wanted at the outset, but also no one is really going to be terribly upset. So legislation is generally introduced by the Commission. Well, it has to be introduced by the Commission. It then goes through the European Parliament, and then European Parliament is obviously elected by direct universal suffrage, and then it has to be approved by the Council of Ministers. If there's not agreement, it bounces backwards and forwards. And then most measures can be then voted on by way of qualified majority in the Council. So it may have been initiated by the Commission, but it has to go through the Parliament, and it has to be signed off by the elected governments of the member states. So it's complicated and arcane, but there's a reason for that. He'd jump back in history, but also the quasi-executive stroke civil service role of the Commission reflects more continental practice than we are used to in the UK. And that is partly because we didn't take part in the founding of the European communities, and the institutional structure with a more powerful, more politicized civil service, which is the way it works, I believe, in France. I'm not an expert in French constitutional law either, I have to confess. Was more of an influence when the communities were being set up, because the UK took a step back and was dealing with empire and Suez and so was at the time. So there is democratic accountability, but it's not well reported in the UK. It has to be said media.
That's true. We've always, there's this kind of phrase, the unelected bureaucrats of Brussels, but it all goes through the Parliament, doesn't it? And we send our own MEPs to the Parliament.
And if you're talking about a bureaucracy, there are fewer public servants serving the European Union in Brussels than there are for the average town council in Scotland or England or Wales.
I can well believe that. I will just mention that you told me earlier there's something like 52,000 instruments, so that's 52,000 different little bits of law and stuff and areas.
Yeah, so that was so there. So there's an online resource, Thomson Reuters, who tried to work out how many bits of law would need to be written into UK law if you simply wiped the slate clean and said EU law no longer has part of our law, and instead we are writing all of this into a giant act of Parliament, or in reality many statutory instruments. So that it would be about 52,000 bits.
So that's what's going to come back in January?
Well,
all those laws?
What the Withdrawal Act did instead was basically say, we'll take a snapshot of EU law, and that is now retained EU law. And effectively that ceases being EU law, and it becomes part of UK domestic law, which then can be amended and fiddled with over time. So it froze EU law as at withdrawal date, if I remember correctly, which is January, or 31st January, pardon me, and courts can, for example, have regard to continuing ECJ, European Court of Justice, or rather, Court of Justice of the European Union, as it now is, case law, which further interprets or develops the interpretation of EU law after that date, but it's not binding. Maybe that's the time I should explain the role of the Court of Justice as the EU in European law, and direct effects and horizontal direct effects, which again can be confusing, but it sets the background to why this is important. So the European Parliament originally didn't have a great deal of power. You had the Commission, which was kind of the government, the Council of Ministers, which is the member states governments, which was kind of the legislature, and you had the Commission, and you had the Court of Justice, European Court of Justice, and that's equivalent to most democracies, where you have a legislature, an executive, and a court balancing the powers out. Now, what became really unusual for what started off as an agreement among member states was the allowance of individuals' rights to effectively bring a case to the ECJ, which interpreted what was then European Communities law and then European Union law. And that made it absolutely unique in the annals of international treaties and organisations. That was then compounded by two things. First of all, the doctrine of supremacy of EU law, which was developed by the then European Court of Justice, and direct effects. Now, supremacy of EU law was part of the community law that we signed up to when the European Communities Act came into effect in 1972. And that basically means that if you have a piece of domestic law that contradicts European Union law, the European Union law, if it is certain, etc., overrules that. End of story. Because otherwise you'd have absolute chaos. You could have laws in different member states that contradicted European Union law, and no one would ever get anywhere. So it is the only way that the European Union can really work. And again, you're talking about laws that ultimately are agreed by a parliament and by the member states themselves. Mm-hmm. So it's not as if some foreign power is imposing laws on people. It's a bit like it's parallels to Scottish independence and having laws set by the Westminster Parliament and the Westminster government without effectively the consent of Scotland. You're still part of the democratic structures. However, you don't have any say in it, and you complain because you don't have enough say in it. And that's basically what the sovereignty argument is about. So yeah, that's direct. That's supremacy of EU law. You also have direct effect, which means that if a measure of the treaties originally and then regulations is sufficiently certain and it is intended to have the effect of law, and it does not require an extra stage, so it doesn't need the setting up by a member state of a body to enforce something like SEPA, Scottish Environmental Protection Agency or something like that, then it can have direct effect. It becomes the law, same as an Act of Parliament or a domestic statutory instrument. Now that applies to treaty articles. Not all treaty articles have direct effect, but some do. And it applies to regulations generally. It doesn't apply to directives. And a little bit complicated there, because a directive can have, wait for it, horizontal and or directive will not have horizontal direct effect, but it will have vertical effect, direct effect.
Oh,
so horizontal means that if you've got a directive, you can, and you're in a court action, you can say the law should be interpreted this way because the directive says it should be, and that's an element of construction. But if there's something that goes against that in domestic law, it won't override it. But you can plead a directive vertically, that is against your member state or a member state. So if a member state has a bit of law that conflicts with the directive, it cannot enforce that piece of law against you, and you can effectively override it using the vertically effective directive. And that can have slightly more wide-reaching consequences because it applies not just to the state but emanations of the state. So that can include quangos of all sorts. It would definitely include SEPA, which I mentioned before, but might apply to bodies that have a public function that you wouldn't necessarily think were, in our domestic context, were emanations of the state. And what is an emanation of the state is defined by what was the European Court of Justice is now the Court of Justice of the European Union, and not ever to be confused with the European Court of Human Rights. There is no such thing as the European Court, despite the media. It gets me almost as annoyed as I get when I watch a law drama on TV. I cannot watch them because I just go, no, that wouldn't happen, even if it's an American one. My wife would just go out the room, Alisdair, because it's just like, no, they would object if that new letter was suddenly produced in evidence and you've never seen it before. You wouldn't be allowed to read that evidence. There is no such thing as the European Court. European Court of Human Rights is part of the Council of Europe, which we retain our membership of, which has a number of things, but the principal thing is the European Convention of Human Rights. Now, the Court of Justice of the European Union takes a close interest in the Convention of Human Rights because it's part of what they regard as makes a modern civilized democracy, but they are very, very different. So hopefully that is
it's a good background, and I think you've answered my first 5 questions all in one go, so that's pretty good going. The only thing was about this thing about Scotland and how Scotland, this thing about if the laws go back to Westminster, the Scotland's argument about some of the issues are devolved issues, so there's going to be some conflict there. But anyway, I don't think we can talk about that.
Do you want me
we must talk. Just give me 2 minutes on that, and then we must get on to the other.
It's really more
stuff.
of a political question than a legal one, because the devolution, the Scottish Parliament is set up by an act of the Westminster Parliament, and although there was a referendum with a convincing majority that was in favour of devolution, it wasn't a 2-step process, but what was agreed and implemented was that the Scottish Parliament would have competence over everything except for retained matters. And obviously no one I forget when the Act was actually passed, I think it was 99, no one contemplated that we'd ever leave the EU, much in the same way that the Northern Ireland Peace Accords were set up, with no one contemplating that we would ever leave the EU. So those competencies were, take agriculture for example, most agricultural policies, regulations, etc., were set on a EU-wide basis, and therefore it was thought, well, administering subsidies and so on, that's fine, we'll just deal with that in the Scottish Parliament. And what was then the Scottish Executive then became the Scottish Government. That constitutional structure means that an Act of Parliament of the UK Parliament, despite what people may argue about democratic deficit, etc., can simply, if Westminster decided tomorrow to pass an Act of Parliament that repealed the Act establishing the Scottish Parliament, it could. Now, there are arguments about
there'd be
whether that's
absolute
democratic
riots
or not,
in Scotland if that happens.
Yeah, but that's the law. Okay, so that's because the Scottish Parliament rests on I wouldn't say a shaky legal footing, but a legal footing that relies upon a Westminster Act of Parliament. A Westminster Act of Parliament can change it, which is why I was saying it's a political question rather than a legal question.
Okay.
What is potentially slightly different, and I know you were wanting to talk about judicial review later, is that although we don't have any text of any reform, Joanna Cherry has certainly flagged that Article 19 of the it's called the Treaty of Union, but the treaty that was signed between the entity that was Scotland and the entity that was England, which included Wales. Before we forget about that, Wales had been subsumed earlier
by England,
as part of England. Article 19 of that treaty, I forget the exact words, but basically safeguarded the Scottish courts and their jurisdiction. Now, there's a suggestion that if the proposals put forward by the Westminster government are as wide-ranging as some say they may be, that might impinge upon the treaty and the law that set up the Westminster Parliament. And that's never really been tested fully in the courts, because largely what was assumed for a very long time was that effectively all the constitutional law moved from the English Parliament to the then Parliament of Great Britain, because the UK only started in 1805, was it? With the union with Ireland. My history teacher would be annoyed if I forget that the exact year. But the constitutional law, which included parliamentary sovereignty, came over and became part of that act, and as if it was continuous. But no court has ever really focused on that. So that could actually be a very interesting legal question.
Test case,
But it's somewhat esoteric compared to the day-to-day issues, which are generally, the internal market bill will presumably.
Yes, I'm glad you mentioned that.
Will presumably cut just because I don't think the text is out yet, but we'll presumably just say we are effectively creating a European Union-like body that will write whatever the labelling is required on your Lorne sausage, whether it's in Scotland or Wales or Northern Ireland, and you won't be able to have a different rule that says you cannot have certain chemicals or a certain numbers of hormones in agricultural products. So again, that is a political question, not really a legal question, because Westminster can change it. And then it's, well, you're great about bringing sovereignty back, but the sort of political point is, well, do you not need a referendum to change the competencies of the Scottish Parliament, because that's what was there. Now, obviously, that's not what the current executive down south wants to hear, because they have policy lines, and as the last 24 hours has perhaps evidence, they seem to be more interested in what their policy is rather than what or how they go about it, put it that way.
So you mentioned Northern Ireland a minute ago. Obviously, that one of the main things they've been talking about today is the border, and how, if they rip up the withdrawal agreement, then that's going to that's going to cause chaos over there, and possibly impact. I mean, it will certainly impact how, and I think even this day, even if they retract a bit, and even if they pull it back, it will, we're still going to be regarded as rather, not very reliable people to be doing business with. And Ireland is just so important, and it's like people haven't realised it.
I think the best summary I've seen of the sleight of hand, the magic that the Northern Ireland Peace Accords came up with was Patrick Keelty, who I don't find particularly funny as a comic, but is obviously from Northern Ireland. I think his father died in the Troubles.
Yes, I think
I might be wrong on that, but he had a string of tweets that summed it up really beautifully. That until Brexit came along, what the Northern Ireland Peace Accords did very cleverly was allow nationalist Northern Irish people to effectively pretend they were part of Ireland, and unionist Northern Irish people to have this identity that they were part of the United Kingdom, which they were firmly in law. But it didn't really matter either way, because there was no border to speak of, and all that changed really was the speeds changed from kilometres to miles and backwards and forwards, and you were largely going to use sterling on one side of the border and euros on the other. So it is a very difficult position, and that's why it took a long time for a withdrawal agreement to be signed, because the May government was trying to avoid what Boris Johnson's administration decided to sign up for, which were guarantees about Northern Ireland, in some respects being part of the EU system, practically speaking, which is obviously a difficulty if you're wanting the UK to just have a nice line drawn around it and say, right, we're going to do what we want to within this line. I don't think there's any text yet out as to what they actually propose, and it's interesting that unnamed sources floated the stuff on a Sunday night, and now they're saying, no, we're not walking away from the withdrawal agreement. We're just trying to clarify things. Whether that was testing the water or some other political device, but that's a political consideration. In terms of the law, they would need to introduce an act of parliament that overrode the withdrawal agreement, which is part of the withdrawal act by amendment. But as I've explained, parliamentary sovereignty allows the Westminster Parliament to override a previous act of parliament. So they can do that if they choose to do so. And the impact would be, in the first hand, political. If you, for a start, if you're trying to sign a trade deal with your biggest trading partner, and then you decide that the most recent deal you signed with them, you're actually not happy with the terms, if that is as far as they go, then you're not going to be viewed as a serious partner when trying to negotiate another deal. It would also impact on other agreements, I guess. Again, that's a political and international trade question, but given also what US Congress has said, probably means you wouldn't get a ratified trade deal with the US. So there are implications on that side, quite apart from the effect in Northern Ireland. There's a constant and unfortunate undercurrent of real danger there that things could slip back. And one hopes that whatever is put in place, that's not going to be a trigger for that.
Well, literally, yes.
Didn't use my words very well there. A cause.
That's quite a point to get to. Well, I think there's just one more thing I wanted to quickly go back to, which you mentioned earlier on. That was Euratom, and you kind of implied that, certainly from its start point, it was kind of a separate section. It was like had an entity of its own, and Euratom is something we've been really concerned about because of things like the radioisotopes for scanning machines and stuff like that. So, I mean, legally, have we come out of Euratom, or are we going to come out of Euratom?
We intimated our withdrawal, I think, at the same time as we intimated the Article 50 notification, and there was comment at the time that why are we doing this?
Yeah,
Euratom doesn't. I mean, I mentioned that if they weren't going to have this device of having retained EU law, there was going to be tens of thousands of bits of legislation that would have to write into UK law. I've never had to come across Euratom because there's not much
to it
to talk about, really. So there was some questioning as to why they decided to withdraw from Euratom, whether it was just a clean break from Europe. I mean, if I recall correctly, the Euratom Treaty and the rules and regulations under it are still justiciable by the Court of Justice. So it may be that politically they decided they didn't want to in any way be subject to it for anything. But Euratom does not affect fisheries. It does not affect state aid. It doesn't affect international trade. Doesn't affect transfer of undertakings or equal pay directives or anything like that. So,
just one of those crazy things. Oh, right. Well, I mean, my brain is boiled now because it's been boiling all day. But you just put a whole load more information into it.
Yeah.
So,
well, the one thing I didn't mention actually, which I'd like to put in context, is I was talking about tens of thousands of bits of EU law, and it does apply. When I studied at university, early 90s, there was a separate thing which was knowing something about then European Communities law, became European Union law. Now, if you are an environmental lawyer, you just have to know the bits of European law that apply, just the same as you need to know the Act of Parliament that applies, etc. If you are dealing with a divorce, let's say, you might have to think about the EU rules that are in place for recognition of judgments across borders, and that's a potential other issue. Recognition of judgments and jurisdiction, etc., is dealt with by some parallel treaties and also some regulations internally. But it might be a day-to-day problem for a civil litigator like me, depending on how things pan out. But there is engagement across the board. But the amount of EU law is still a lot less than we churn out domestically. So, for example, this year, and it's actually the numbers have actually gone down, but to Friday's date, we'd had just under 1,000 statutory instruments this year. Most of them won't have had anything to do with EU law or the transition or anything like that. 273 Scottish ones. And you might think, well, there's been loads about the COVID-19 pandemic, etc. Well, actually, those numbers are down on average, because the average is about 2,000 statutory instruments a year in the UK and about 400 Scottish ones. So people don't realise that there are acts of Parliament and acts of the Scottish Parliament, but there's a lot of legislation that comes out that are statutory instruments that, if you're looking at a book, it's really thick and tiny thin slices of rice paper almost. And that's not including things like tax rules and so on. So EU law is voluminous, but is by no means greater in volume than domestic law.
Okay, so we're not talking Dickens, are we?
Well, we are, but
Okay.
you might take Dickens as the EU law side of things, and I'll raise you a Tolstoy for the UK legislation.
Oh, I like a literary reference. Just before we go, I think Paul has one question that might have come in. Let's bring him in for a second.
Yeah, so just thinking about some of the sticking points in negotiations with the EU, obviously one big one is this notion of a level playing field. I just wondered if you could explain a bit about what that is and why that's crucial from the EU perspective and why it might be crucial from the UK perspective that we don't have that.
So a number of the rules that the European Union has are about or were aimed at creating a level playing field. So if you go back to the three original communities, and in particular the European Economic Community, what it was trying to do was pull the economies together by freedom of movement of people, workers, capital, establishment and goods. And that's fine, but what they then realised was they would need to make sure that there were shared minimum standards, because if you didn't have those, then you could have what can be called social dumping, for example. So in the 80s, there was much talk about employment legislation that was coming from the EU because the French and German systems had better labour protections than Thatcherite Britain wanted to have. But interestingly, one of the key drivers for levelling the playing field was actually Margaret Thatcher, because she was a real driving force behind the single European market, which I think she viewed as one of her great achievements, because it pushed through a lot of legislation quite quickly in 5 or 6 years to allow the coming down of borders. I am just about old enough to remember suddenly being able to go across borders and take whatever you wanted across borders. And that didn't happen before the Single European Act. Now, there are slight changes to the way or to the competencies of the European Union, but many of the competencies have grown out of that levelling of the playing field. So environmental law, because you don't want someone having a chemical manufacturing facility or whatever in a particular member state because they don't mind if you dump everything in the rivers, to put it bluntly. Likewise, employment protection laws, you would maybe build your factory in a country that allowed you to hire and fire employees because you didn't like the cut of their jib. But that would provide you with a great deal more flexibility. But you can't do that because there's a levelling of the playing field. State aid, which is one of the things that is cited in the current friction over the withdrawal agreement, again, so that if you have a steel producer in Italy, let's say, and one in Wales, because that's, I think, where the primary foundry, what's left of British Steel, now Tata Steel, is state aid regulations would then not allow, let's say, the state of Tuscany to pump money into a loss-making Italian producer, which would give it a competitive advantage over a British producer, for example. So the levelling of the playing field is pretty important. And it has to be said that if I were a European, most of the steps that the Westminster government have taken recently would tend to suggest that I wanted to have any rules on levelling the playing field cast in stone, written in blood, with hostages taken to ensure compliance with it.
Right, written in stone, cast in blood. In fact, that was the wrong way around. Cast in stone and written in blood. I told you,
like
made my head go.
It'd have to be the blood of one of the aliens from the Alien saga to actually cut the stone, obviously. But
oh dear. Right, I'm going to have to listen back to this again, because you've just been so full of information, and I've been it's been really great listening to you, Alisdair, and I hope everybody else is feeling informed and perhaps slightly overstuffed in the brain, but no.
Well,
it's been
if it's
really
any
useful.
consolation, my wife refuses to watch documentaries with me because I go, hang on a minute, that's not right.
Yeah, well, I'm like that with school programs. I go, I'm always criticizing those because I was a teacher. So, it's the same thing. It's about specialisms, isn't it? So, it only remains for me to say thank you so much. And next time we need a compare. So when we're going back in, we'll get you along for that night as well.
Well, I'll have to be quiet then, though.
No, I tell you what, we'll get you a better PA as well. Because that was terrible. Anyway,
No worries.
It's been great having you on. Great seeing you again, Alisdair, and thanks very much. Thanks, everybody.
Thanks very much.
Bye. Bye.
Thanks, guys.